Hi guys, it's Kathy. I hope you're doing well. This Monday morning, it's Monday, so I hope you're doing as well as you can do on a Monday morning or Tuesday night for wherever you are. Wednesday afternoon, I don't know what time it is wherever you are. So we are starting this with closing statements. So we're not watching the whole trial. The audio is bad enough that I didn't want to get the whole trial, but the story is good enough that I wanted to get it. So I put the captions on to help with the audio, although I didn't double check all of the captions. So maybe it'll say something interesting. I don't know. Hey, I'm always on time. I make the time. When you start paying me to be on time, then you can say something. Until then, I'm going to take my $3 for this stream and start whenever I want to tomorrow. Yeah, been doing it for 3 years. Whatever, it's fine. Actually, you know what? You're not going to believe this, but most of my income from this stream comes from my members. Comes from memberships. I'm going to tell you how many members we have here. We are a team. I'm going to tell you how many members we have as soon as I find that answer. It is community. All right. I'm almost there. I'm almost there. Okay, I'm not almost there. I'll find out, and then I'll tell you. And just so you know, almost everybody they pay the $1 or 99 cents, and I get half of that. So hold on, I'll tell you in a bit. YouTube doesn't make it easy to find how many members you have. Yes, they do. Dashboard, nope. Yes, they do. I remember now. Dashboard. See all members. 282. We have 282 members. I get half of the price that you pay. And most of my income for this channel comes from memberships. Yeah, Granny, that's because I did something nuclear. I did something nuclear that if the doctor would find out what I did, I would get in so much trouble. Jude, thank you so much. I appreciate it. Thank you. I didn't say all that to make you give me $5. I'm still going to stream. I'm just stupid that way, you know. I enjoy our time here. I do. Here we go. Let's go to the brother and sister are lawyers, okay? But a couple interesting things happen. So, brother started a law firm, not with sister. And then he built it a bit. And then it became big enough. And sister is like, oh, bet, I'll just work with you. And she did. And then at some point, she was out. She wanted to leave, or he kicked her out. I couldn't exactly tell which. And then all of a sudden she said, yeah, but I'm the partner. I'm a partner. I own this. This is mine. My business. And brother was like, wait, what? No, you don't. She goes, oh, yeah, I do. Look, you called me your partner in all these places. She brought receipts. You called me your partner here. You called me your partner here. You called me your partner here. You put me on your bank account. So they're fighting in court to see if she actually is a partner. She did do something, though. She went in months after she left because he put her on the bank account, and she withdrew $75,000, which is why he sued her. So, V, thank you so much. I absolutely did not mean to make you guys rip open your wallets. Look, life sucks right now. You do spend your money on you. Go buy yourself some I don't know, bonbons. I don't really know if they sell bonbons. That was a big thing in the 80s. You know, if you wanted to treat yourself, you'd get bonbons. Or if you were a bum housewife, you would sit at home and eat bonbons all day. You know what I mean? But maybe they still sell bonbons. You could go get some bonbons, right? Maybe we should all get some bonbons for next stream. But not this stream, because this is all family drama. Brother and sister. If the audio bothers you and you just can't take it anymore, just tell me and I'll just turn it off. I don't care. I already saw it. I already know I saw this movie before. I have other stuff. Here we go.
I want to thank you first, and thank you for coming to sit on the panel. And I was thank you for the time that you've invested. It's very important.
It does get better.
Very important what you're doing, and we talked a little bit about it with our. As lawyers, what makes us job so stressful and difficult is you don't get feedback. Talk to you one time, and then you sit and you listen to everybody talk. You don't get to ask questions. We don't get to give you a pop quiz or anything. It's like we learned in teaching that there's certain things you can do to make things easier for the student by asking a question. Right? If you understand, like you understand, Jennifer, how they're doing, and when you get to, try to alter your lesson plan a little bit to help that student, or at least measure it and see what. We don't do that. We just present a whole bunch of stuff to you. A lot of times we don't even know what the judge is looking for in questions. But this time she told you up front. She brought you in here, and
I think, but I could be wrong. I think bonbons are like a little ball of vanilla ice cream dipped in chocolate. I think they're ice cream. They could also be some sort of candy. I don't know. Because I didn't eat them when in the 80s, when people were sitting home eating bonbons, that wasn't me. I was a kid running around. I would never get a bonbon. No one would ever throw a bonbon in my direction. But I think Monica says yep, so I'm right. I've heard a lot worse audience.
The judge said I had one question. I need you to answer a factual question. Well, I can do mine. She determines the law. She applies the fact. But in this case, there was a factual dispute over some of the evidence. And so that's why we give it to you. Now, this happens in a lot of cases. So you can have a car and you can have a videotape of the wreck. And you see this car run this red light. You still have to assemble the jury. Because we have to admit that it's verifiable thing. We have to make sure that the evidence wasn't altered or something like that. And we go through this process. You heard us many times, being with Farrell, laying the foundation. It's a truly correct the process that you go through. When we reach the end, the judge determines whether that's admissible. That's what you're going to get, plus the videotape. You're going to get this evidence when you go back into deliberate. So now you say, well, Mr. Kelly, why are you arguing? Why are you this morning? Why are you don't stand up here and wasting our time? We're ready to decide. And I've seen this many times too. The jury sits there, all of you, and you thought everybody heard the same thing you did. You thought everybody heard or saw exactly the evidence that you did. And you get back in the jury room, and what happens is somebody heard something different or took it different. And so that's why this judge gave you these instructions. You have to make up your own mind first. That's the beginning. But we didn't just select one juror. So that was going to use the judge, right? We have 12 of them. So that means you have to deliberate. It doesn't mean you alter your beliefs or your feelings about the answer. What it is you got to be open to listen to somebody say, but remember, this person said this, or remember this document, and then you weigh that. So the whole deal is to collaborate and to discuss. And the judge said, all of you must do that together because it has to be a consensus decision. If one of them goes to the restroom and they're going to stop. It is very important. Everybody participate. There are talkers and there are listeners. And some people are shy. And every one of you took an oath and every one of you told the judge you can get on here and you can participate. You can talk You can give your opinions, right? Everyone is equal, and you're required to say, this is why I believe this. Guys, come to consensus. Now, we don't lock you back here and keep you here forever, making you all agree. Now, some states do that. I was in a trial in Louisiana. I forgot it was Louisiana.
That's not true, is it? In Louisiana, they have to stay until they come to a unanimous decision. The jury, that can't be true. I'm saying that's not true, even though a lawyer just said it was.
You got to come out unanimous, or they won't let you go. They won't even let you go home. But we don't do that here. In a civil case, I told you that, more than the judge limits the time. Very, very strict. Some cases I've had to go 6 weeks. I've had a case go 3 months. In a civil case, certainly criminal can go longer than the OJ was about 6 months. And they just keep you locked up. But in civil cases, we lower the burden of proof. In this case, I don't want you to think I didn't bring you an enormous amount of evidence. But we were cut off. You'll notice that sometimes I didn't have more questions. When the judge asked me, do I have more questions or something like that, I said no, because I knew the judge had told y'all it's about 3 days. She was going to try to get you out of here. And y'all had this agreement coming in here that we were not going to give you everything we both sides had. We were not going to be allowed to talk everything we ever wanted to. We had to make decisions that this is what we needed to answer the judge's question. And that's what you're going to get. So you got enough to get the standard that the judge gave you, which is a preponderance, more likely than not. I think we gave you a whole lot more than that for our side, and I'll tell you why. But even if I had that videotape of the car wreck, still got to come in here and talk about all of the elements and go through it, why that videotape is in support. And in this case, I do have a videotape, and I showed it to you, Exhibit 1. In a few minutes, I will play it again. But why do I think that's so critical in this case? Before I answer that question, I want to back up just a second and tell you why it is so important that you're here to do this job in this manner, in this proceeding. The Greeks gave us 3 things that I absolutely love. 1 is democracy. 2 is drama. I love fear. And 3 is the jury. And
what about yogurt, sir? What about yogurt? They're better than all of those things.
Ever since have struggled with all 3, right? Especially democracy and especially juries. And so juries that have real long history can be, first, they're not quick and they're not easy and for a lot of people to come in. But what's the alternative?
Brent actually delivered the first 7 SmackDowns before Granny even got one in. So.
And the judge told you this. This thing was never in court action.
And you left the towel on the floor, damn it. What's wrong with you, you heathen?
He said, this is not a perfect system. This is not probably the absolute most efficient way to do this stuff. She's done the best so far on the planet.
Bobby, you look so good in green.
Because there are 2 competing goals. Efficiency and fairness. And that's what human beings that has to struggle with is fairness. Now, if I can start off, Miss Farrell and I have been joking that we're both Irish. Is your son here?
He's sick.
Oh, I'm sorry.
Yeah.
This is really bad. There's a famous story, and a quote from a history book that said, I'll tell you a little story that I love. About 1,000 years ago, a little more than 1,000 years ago, there was a high king of Ireland, and his wife owned some land and some sheep from a neighboring sheep farm had wandered over, a little flock had wandered over to her land and it had eaten on her grass. And so she just seized all the sheep. She just took them all. And the farmer said, well, it's not fair. The Bible seems like just horrible. He said, High King, I want to try. The king became he became the judge of his wife's own case. This is the most important part of this is he gets the wife's case and he decides for the wife that she can keep all the sheep. And the subjects, the king's people were so outraged that they revolted and they exiled them. They thought it would be something fair, like, okay, you did compensate for the grass and shit, but you don't get to keep all our sheep. That's just cheating. It's not fair that you, the king, decided in this case. It was biased, it was corrupt. And they exiled both the king and the queen and brought in a new king. So The history books tell us that no nation of people under the sun love equality and indifferent justice more than the Irish first. Though it be against themselves, they honor that principle.
A, the queen would never have been allowed to own any sheep if there was a king. They would have been his because he's the king. B, their subjects don't give a shit about their sheep and who ate what and who kept what. They don't care whether the king and the queen have sheep and they ate on their grass. So none of that story ever really happened in real life. Just didn't.
Indifferent justice. We translated that to blind justice. So what's your job first? Your job is in the first line at the bottom. You can push that up a little bit. The judge's first instruction to do not let bias, prejudice, or sympathy play any part in the sin. We're not here on a beauty contest with who dressed the best or who's the nicest, or do I vote for the man or the woman, or do I vote for anything? Nothing about that matters. You got a factual question. It's very simple. Go to the question. And it has elements. We're going to go to the question. Did they had a partnership? They called it this. And we're going to look at those elements. No, that's the elements. Go this way. That's your question. There you go. I've already answered it. Well, I'm going to show you why the evidence answers it against. But none of this is about does Lemma, when she had independent contractor, and she owed wages. We're not here for that.
Just so you know, there is a male attorney that is for the sister, and there's a female attorney for the brother, which messed me up a couple times, but now it won't mess you up. So he is fighting for the sister right now.
The judge needs this answer to do her job. And so that's why she's limited to this question. Now, you heard a lot of stuff, and I'll tell you why you heard this evidence. And you're going to say, well, that's good. Yeah. And I'm going to show you why most of it does. But so the point is, you're to decide a factual question that the judge is giving you based on the evidence. And then we're going to go back to the elements and give the elements stuff. One of the things I remember talking to you about is when we started this, didn't realize it, we just opened the day for baseball. And I remember that they had to pay an exorbitant parking fee coming in. I didn't realize it was open today, so I'm over there rushing before I had to pay this big fee.
When I went down to see Judge Fleischer, it was, oh my gosh, was it opening day? It may have been opening day, the second time I went down to see Judge Fleischer. And they were playing at home. And from my hotel room, you could see right into the stadium. It was pretty cool.
Now, and I told you this in Board this is the song. That's what I have to do. This is the land of the free and the home of the learned. That means two things. One, I took it a little bit in my opening. It's the land of the free. We don't have, like a lot of countries, the civil system in France and in Spain, Mexico, Latin America. They have a civil system. In order to form something, you got to go to a government official and get a stamp. You have to get their approval to be a group or I forgot what they call them in France. But you have to actually go to the government and get approval for doing your business that way. The English system, the American system,
the Houston Astros
is the free. You're free to do it however you want. Problem is you're responsible. See, it's free, but you have to be brave. You can either do it right or you can do it wrong. If you do it wrong, then we have backup rules. We have backup mechanisms. And I'm going to show you how this works in business. You're not required to go to a lawyer to do business as a solo practitioner. We talk about that here. You're not required to go to the government and get your approval to do certain things. You are required to be a lawyer. That's a statute because there's a lot of abuses. Before we made them take tests and get licensed, And that's the point I was trying to make, that we're different. We have rules. This whole thing is structured on rules, and we have to stay to the rules. And so, but the brave part is you got to do it. You got to, try to do it. And if you do it with more than one person, as you see this instructions, if there's more than one person, two or more, we consider that a partnership no matter what you call it. So you can call it a joint venture. You can call it whatever you want. You put a name on it, a DBA. In this case, the DBA is a Lloyd and Selling PLLC. You call it whatever you want. Nobody's going to sanction that. I don't care where, I showed you where you can.
Brad, you missed it, by the way. Last stream, CJ had sent me some Vegemite. And I tried it last stream, and I liked it. It was really good.
Go to Home Depot, Office Depot, and you can get them to print all that fancy stuff, stock certificates. The government doesn't issue that. You file it, they give you a number when you file it. That doesn't mean that structure has been approved by anybody. That has to come to court if it's contested. Or if there's a problem like the Attorney General, somebody gets after you for doing something. So until somebody makes a complaint, you're allowed to be brave and do it your way. You can go into business with anybody you want, whether it's a family member, a total stranger. You're free to do it oral, unless the law requires it to be in writing. And certain things have to be in writing, like deeds, real estate contract. But just doing business together, two lawyers doing business, doesn't have to be in writing. But you can. But then we have all these other structures that the government has approved or forms. You can be certain LLCs, PLC. But you heard he did LLC, he knew that was wrong, he had to change it. That doesn't mean he's not practicing law, or Mr. Michelle is not practicing law, or the other people practice law. What their requirement is they have to have a law. So what is it when we look together to see what were they doing together? And that's the evidence that we're going to look at in just a second, is you don't need to say, did the government prove their partnership? Or did these documents prove it wasn't a partnership? Because that's not in your judge's instruction. Your judge's instructions tells you what you're to consider. Regardless of whether they intend to create a partnership, the one guy comes in, now that, there's a reason, I didn't intend to create a partnership. It could be for liability purposes. I'm not your law partner. I don't want to own up to the malpractice. I'm not your law partner, so now I don't want to share profits. Any one of those reasons is invalid. What we look back is in time, as at the time you start. When you two, it used to be you just shook him. That's how the old method of doing business. A lot of these LLC stuff didn't exist. Any corporations don't exist until 1900. Corporations are actually governed now by federal law because of all the stuff that happened in the 30s when the stock market crashed with a lot of cheating law. So we get it regulated by the federal government, and then the state comes in non-public. But all that changed by statute. Okay, we're going to have corporations, we're going to buy stock, and that changes it. We're going to have limited partnerships. Those are written agreements that limit your participation. Limited partnerships, like we heard others are written documents. You get filed. You do have to make those public and file the right thing, because those limit.
It sounds like it, T. Sounds like it's a common law. Common law.
But you can take. If you're a 1% limited partner, it'll say that in the document. You're a 20% limited partner, it'll say that. So these huge firms, mega firms, thousands of them, will usually have limited partnership like we talked about with Porter and Hitchens. They'll have 500 partners, and they'll tell you, okay, and every time a new partner comes on board, they tell them what it's.
Oh, but when I do it, then never mind.
There is not stopping it. But you're a partner in a limited partnership, and it's governed by that document. But that you're not required to have it. If you don't, again, the law has fallbacks, just like this. It's equal unless you've limited it. Your partnership arrangement is equal unless you have a limited partnership agreement. So, what are the factors? The receipt. You look at the or. The judge gave you an or because it means either or of those things. The receipt or the right to receipt. So if I shake hands with you and say, we're going to split money, we're going to split my hourly rates. That's the right to receive something. So I'm going to work with you. We're going to split our profits. We're going to split our revenue. I'm going to bill. You're going to take half, and later on we're going to do something else with it. That's the agreement. And we look at the time of the formation of this. And the receipt, did she receive it? Yes, she received it. She billed, and she didn't get all of the stuff that she billed. She got a portion of it, and she testified that she then left the others in there to grow with it. The right to receive, and she did receive. And they billed. She didn't always get what she was promised. Now, expression of an intent to be partners in the business. I'm going to show you a lot of documents and exhibit one in a few minutes, but that's undisputed that they told the public that they were partners. Limited is my litigation partner. Limit is my business partner. I'm going to show you those documents in just a minute. I'm giving you remember the overview so I can then get into the weeds. But I'm trying to get everybody on the same page that Lima Lucelli built the litigation side of this partnership. There's no dispute about that. There's no dispute. He called her my limited partner. My litigation partner, and he called her my business partner. He used that word twice, one to bank, then to the public. Repeatedly to the public, called her my partner. The agreement to share or sharing. Either you agreed to share, or in fact, you were sharing. And yet, here's the judges for losses of the business. Of course, they were sharing that. If they didn't get money, he didn't pay. But this business never had a loss. But they agreed to share the losses. That's why they went into business together. But it could have been a disaster. And Lima would have taken it just like everybody else would have taken it.
I happily tried what CJ sent me. Easy. I did it. She sent it to me a while ago. I did it a while ago. This was the second one she sent me. So this wasn't the first time I've eaten it. I've eaten it. I don't know if you guys remember when my computer was downstairs. Bobby, there is not enough money on earth at all that would make me try anything you told me to try. Even if you said, try this ice cube. I am out. No, never.
More importantly, agreement to share or sharing liability for claims by third parties against the business. Where do we see that? His complaint about the malpractice. There was an email that they put in the evidence about malpractice. You're exposing me to malpractice and my firm. Right? Why would he be exposed if she doesn't even get a contract? Why is he exposing? They're both exposed. Let me explain to you. Let me explain to you. They're both on the pleadings as Lloyd Lucelli, PLLC. I showed you those pleadings. They're both responsible for malpractice in their case. That automatically indicates they're sharing the responsibility for potential loss. If they mess it up, and an email is using her and some other lawyer that work for us, of messing something up, they're both exposed to the losses. That's what that's talking about. And then finally, the agreement to contribute or contributing money or property to the business. What was contributed? Their labor. Remember we talked about sweat equity. That's all they both do is that. Sweat equity.
Owners don't use sweat equity.
Up there, I wrote up sweat equity because that's what they brought. That's what lawyers bring, especially in the situation where it's all virtual. Overhead was virtually nil except for his travel expense. And he was writing on travel expenses before he even worked in this in the firm. He said, I was at Apple, but I had this. And I said, do you have any revenue? Oh, but I had expenses. He was just trying to expense it. So really, that's all they ever had was some communications and some expenses for travel. Everybody told you, including Miss Beth Lemire, that I love working at home. So they put all the capital of this thing, what would normally have been an office, he put it back on the employees and the lawyers, and everybody's working at home. So they try to get their house to help build this virtual business. And that's fine. Generally what COVID taught us, right? Excuse me, I'm about to get out of here.
That means you're talking too damn much, sir.
So why are we looking at all these facts? You heard some facts that you're going to, and I'll talk about it in a minute. Some of these facts didn't seem to fit, but there's two sides to a factual question. One, if you have just undisputed stuff, like a videotape, like a story. We play the videotape to extend the evidence. We have that. We have them saying, this is my litigation partner. We have the documents, but it's not undisputed. So you still have to get that. But then when we look at the testimony, see, the judge also gave you a specific instruction about testimony that's different than like a videotape or a document. Once you find that document, his own statements, then we have a little contest over who he said, she said. In this case, the actual difference is very small. Him saying, well, I didn't mean to use partner like that is an afterthought. Him trying to get an excuse why he used that word is not relevant or legally binding on. But he said partner. He repeated it to the public, and these factors were met. But why did he have to come decide? So the other part is credibility. Credibility. So let me give you an example. I didn't even stumble across this. It was Miss Farrell was asking him a question about Linda's been fired.
I don't understand your question, but she is suing, saying she was half partner, one half partner of the whole business. Even though when she left, she took all of her clients with her.
He shows you the email, and I think I have it. I can take you a second. He shows you the email that says, you've been fired. You're leaving.
See, they say both. They say she was fired, and they say that she sent an email saying she's leaving and she's taking all of her clients with her. So I don't know which is true.
July 14th, 2024. The whole testimony was, and it was elicited by Miss Farrell. And she says, this is Exhibit 39. By this point, he's already told you under oath that she's out. She's leaving. He's also told you, well, I never showed her any information. Yeah, she asked for more money, but I didn't want her to have her look at my books and records. But then he says, you weren't at the CFO meeting. CFO is, the financial officer, right? Company financial officer. And he says, right here, he's after Lemma, and she says, well, I'm out. And then Miss Farrell says, why did you want Lemma at a CFO meeting if she's out? And he froze. He didn't have an answer. Transparency. That was his answer. Transparency. Transparency about what? You just told us she had no rights to the book and records. You weren't going to show it to her. You showed it to Megan, but not her. She was on the bank account. But then you try to, well, she didn't really have access to maybe she had limited access. He tried to say, well, she didn't have access to a bank account that she had signed on, but you couldn't go look at it. So he got caught with a lock. That was not the first. But his credibility starts going down. And that's what you look at for credibility. You look at these incidences of dishonesty. Because that's where you have to make the judgment call on the testimony heard. In this case, I don't see it as that difficult because almost all witnesses testified as to the important facts that we're looking at, almost the same. The only one that tried to worm around with it was Mr. Ferris. By saying, I used the word partner because she really wanted to be named a partner, but I never meant it. Well, it doesn't matter what you meant. It's what you told the public, what you intended, what you represented. Remember the top, even if you didn't intend to, it will happen because of these things, your conduct. Well, we'll have the law call it a partnership. The facts have to conclude it was a partnership and you're doing these things. So the other thing was, and I did see this one, about exposing each other to risk. He even complained about it. How are you not sharing liability? This is 33. The work you have done is to expose me and the firm to malpractice. Our Our insurance premium is to cover a single claim. He didn't say my insurance policy. He said our insurance policy. And it's
My boss would say that to me too. If I left ice all over the floor, he would say, our insurance policy will go up if someone falls on that. That doesn't mean I'm part owner.
consistent with what he told the bank. 48 and 49. Now, this one also caught me because there was a couple of things in here. You don't have to be none of those things the judge showed you were deals. None of these says you have to be the sole person in control or you have to have the ultimate authority. Even Ms. Revere agreed with me in big firms. Usually there's one guy and he makes all the ultimate calls. But the thing can't work all down here. But everybody equally has to meet every day to vote on everything. Usually they give that power to somebody. In this case, you can tell that Mr. Muselli is, wherever he's at, is going to start telling everybody what to do. So, what do we have?
Again, when I go to work, I just tell everybody what to do. That doesn't mean I'm an owner.
He uses a word I thought was very interesting. I want to go to the part where he's telling Chase Bank in 2020, right? This is the beginning. I don't know if you can see that, but you'll have it. This is Exhibit 48. This is Chase Bank. Please meet Lemma. They actually use the words my Lemma, my business partner, right? And coordinate with her on the documentation to get on a bank account. What's important about that? Bank accounts are something you expressly control. If they're yours, you don't put random people on there to be signers or responsible. Remember, when you're a signer on a bank account, you're sharing the liability for overdrafts and everything else that could happen with it. Forgery and stuff like that. That's going to come back to you for analysis. You are responsible on that bank account. So, and it was, suddenly the answer was, oh, that's a typo. No, it's not. He did it again. Another day, 2020. Please meet my Lemma, my business partner, and coordinate with her on documentation. Our law firm in Texas.
Our law firm doesn't mean that she's an owner, but my partner actually does. He did it twice. Once to a bank. So,
Law firm in Texas. Not mine. Didn't even refer to as my sister. It's my Lemma. It's consistent with his belief when he said, remember his testimony, I put her on a tight leash. Who talks like that anymore? Do you really think that that's appropriate way to refer to anybody that's especially a female in our society today? Could have gotten away with it 100 years ago. This is why I think justice is very important. It has to be no bias, no sympathy. Because he cannot be just allowed to dominate because he's a male. We've all learned that that's no longer appropriate behavior here. And I don't care what he did anywhere else. The rules that we're applying are here. But nobody is to be denied justice anymore. Nobody is to be treated as a second-class citizen. Nobody gets less than full rights. And my Lemma, I don't put her on a tight leash. He said they did that in January. I don't know anybody on a leash. Just those verbalizations alone indicate, yeah, he makes promises, but he never intended to keep them. That's a different case. It's a different question that the judge may want to ask. But in this case, we're just looking at what he thought he had control of everybody. And he thought he had control of them. But that doesn't mean she's not a part. Not one.
T, you're my wife. You're my wife.
One of those questions that says, was she sole control or had to be equal control? It says, did she participate or have a right to participate in the control business?
Mr. Kelly, I just want to advise it's 30 minutes.
And we're there?
30 minutes.
Okay.
So if you're just taking it from the other side so that you know.
What? No, Judge. No. So they only get an hour, period. The judge is going to cut them off. And she just said to him, "You're taking time from the other side." No, that's not fair, Judge. You need to cut this man off. He doesn't stop anytime soon. I mean, he does, but you would think if he knew that, he would stop. No.
Be more efficient. Ladies and gentlemen, the jury, I've shown you the evidence that don't exhibit one, those that's the video. That's the expression, her right to receive of the murder testimony. We also know that she did, that's undisputed, participation or right to participate. She participated, she hired you. The agreement to share losses, I've shown you that, and the agreement to contribute the money was the you can't say this wasn't oral partnership or something like that. Remember, if somebody said, well, it's not in writing. Remember, Jason Lloyd was never in writing, but he was clearly the partner. That's his name in this. And all of the attempts to deny, I'm going to shut down my thing. All of the attempts to deny Jason Lloyd was a partner were undone by the witness they called, Miss Rivera. Now you say, oh, Jason Lloyd now this forever.
Vegemite.
Had nothing to do with it. And she tells me, Miss Rivera, very honestly, well, he came to an all hands meeting for company meeting for decision making while I was there after 2020. Jason Lloyd showed up. Now, I don't want you to get confused. Jason Lloyd didn't appear in this case and is not arguing he is a partner. And this question doesn't ask who all the partners are. The question just asks, are they partners? Did they agree to be partners? So Jason Lloyd may still be a partner. He may not be a partner. But what we conclude from
the brother is talking to his lawyer. That's what you hear, Jude. The brother is whispering in the microphone to his lawyer because they're lawyers. They're very smart. Yeah, this is his closing. These are closing arguments before the jury goes and decides.
Jason Lloyd it was oral agreement to be partners, oral agreement to have Lloyd and Muselli in the name. And he may or may not be a partner, but Lima is certainly at least as equal to what Jason Lloyd ever was with oral agreement to be her partner. He has absolute admission of that. Thank you, Judge. I'll preserve my time.
Right?
You'll preserve what time, sir? You get an hour. You already used 35 minutes of it. She gets 25 minutes now. Unless I'm wrong, unless I heard it wrong. But no, I didn't. She said it out loud. You're taking from the other side.
Is the defendant ready for their closing statement?
We are. Can I have just 1 second to get my machine? I want you to have. Good morning. Thank you for bearing with us these days. I know there's a lawyer joke in here somewhere, but I haven't been able to think of the right ones. I think, like Mr. Kelly said, it is helpful to focus on exactly the question you're being asked. Did Ferris and Lima create a partnership known as Lloyd and Muselli PLC? Right now, I think you'd say, who knows, but you keep an open mind. You don't know, question marks, right? And like you said, you've got the evidence that you've heard from the witnesses and the documents that you'll take back to you, the exhibits.
My computer.
To try to determine on the preponderance of the evidence what the answer to that question is. So I'm going to show you some things that I think will help you, some things that you've heard of all the many things you heard, relevant and irrelevant. I'm going to try to show you a few things I can help you answer that question. This is part of your instructions, and we talk about each of those 5 factors, and you've heard a little bit about those 5 factors. You have the entire, I spent a lot of time on the entire corporate structure of the PLLC and who owns what and all the share certificates and everything. But let's leave that aside for just a minute and just focus on the fact. Right? Pretend that there's no doubt who owns the shares or the member units, or there's no doubt about that. But let's just talk about the relationship between these folks, the business that they did together, right? As brother and sister, and ask, did they come forward as co-owners to build that up? The law firm already existed by the time Ms. Verratti, now Sally, became involved. She had been working for other people. From the time she finished law school until 2019, when she finally looked at what had been built and thought, this is big enough for me to now come and join. You heard testimony that was not controversial. That when the transactional clients, the business clients that Ferris had litigation problems, he was sending them elsewhere. And eventually he thought, we've reached critical mass where it's time to put on a litigation division on their existing practice. And then that's when Lemon comes on board, which conveniently aligns with the fact that she didn't have a job at the time. Until then, all the time that Mr. Maselli is building a business, she is working for other people. She's not a co-owner with him, taking risks, building client lists, absorbing liabilities, earning profits. She's working for Howard Nations. She was working for the prosecutors. Well, he is building a business.
I'm
Then she
pretending my
works.
laundry is already done.
As an independent contractor, not as a co-owner. And we don't need to listen to him, to Mr. Maselli, look at any of the documents. We can just look at her ones. Her contact. Ask yourself, does Ms. Maselli act like an owner? And so I'm going to show you a few things that hope help you answer those questions. This is just a prettier version of exactly what the court gave you. You can see it. Thanks to Ferris's brother who put these pretty slides together. The documents you've got back there. Now I know you've been listening and paying attention, and it's funny when 12 jurors come together, it's like greater than the sum of its parts, right? Between you, you've heard it all. You picked up on every inconsistency, probably noticed things in the documents that we didn't. I'm going to point out a few things that I think are important. So what I mentioned just a moment ago, when she joins, she signs the contract.
Texas next in the
She signs the contract as an independent contractor. Why? Remember Beth Revere? Beth Revere said, I signed that contract too. I was an independent contractor. This is Exhibit 24 in your life. The last line of last line of the first paragraph, the very first thing is, this agreement is not to be considered a partnership or joint venture, and L&M will not be liable for any obligations incurred by the independent contractor. She signed it. Now, talk about credibility. Anyway.
I know I'm not JK, but if JK were here, he would say she signed it as an independent contractor. That kind of makes her, I don't know, an independent contractor.
She said it was a forgery. She said, the first time during this litigation, I understand. That's not my electronic signature. So we got out the audit trail, showed you the audit trail, you've got it on the back. And you heard Mr. Maselli testify. Not contradicted. You didn't hear any other evidence that they were together when it was signed. That on August the 9th or August the 6th, they're together in Turkey, and he said, hey, you're going to start working for the firm. We have to get this under contract. Guys, these are lawyers. If they had an agreement to be partners in the firm together, why on earth would she sign this? Where it says it's not going to be considered key in partnership or joint venture. Talk about doozy, right? She would look at that and say, I'm not signing this. This is a lie. This doesn't describe our relationship. She doesn't. She signs it. And moreover, she accepts payment under that agreement for 4 years. Every single document you take back with you, every time she complains about money, not complaining about the partnership, but her interest in the owner, she's saying, you're not paying my wages. You're not paying me what you promised under the independent contract agreement or the origination fee agreement. And you know, one of the ways that you know that that is credible is because you heard two other people say,
I changed that. Okay, all right. Think about it. in all the lawyer shows that I watch on TV about law firms, you join a law firm, as real low in the totem pole, but then you work your way up to partner. So maybe she did sign that way at the beginning, but she worked there for a while and she brought in a lot of clients. Maybe it changed. I don't know.
I'm gonna always get paid the hours that I fill. On both sides, right? You heard Shay Palavan come up and say there are discrepancies in what I billed and what I was getting paid, and it's Ferris's fault. And you heard that.
The captions should say build, not build. Build, not build.
Revere on our side say the same thing. She put her hours in Blockify or whatever, Clio, and then when she would get her check, she'd be like, I think I billed more hours than that. And who did they blame? Ferris. Blame him. And so, and you heard Beth saying that when she complained to the head of litigation, the litigation partners, Lena, she said, listen, partnership's the title. I'm a contractor just like you. I can't do anything. I don't have any power. That's the factor that talks about control. You can think they should have given money. You can think that she should have owned part of the firm. And I think that maybe Megan should own part of the firm, or maybe I should own part of the firm. Right? You can think that was not their call. And if she wanted to make that deal, that's the deal she should have made. She should have refused to sign that. She should have refused to sign the origination agreement. And when offered the morsel of a $10,000 month management fee, she should have said, what about that? No. Where's my distribution as a partner? Instead, what did she say? Thanks, Ferris. She's not an owner. She never acts like it.
Yo, if I worked for my brother, I don't have a brother, and I made $10,000 a month working with my brother, I would say, thanks, Ferris, too. I would say that. Yes, I would.
Yeah. That's what I said. Exhibit 25, I've got it back you. Back there, you will take it back. The origination agreement. When you bring clients to the firm as a thank you, you get a bigger percentage of your own billings. If you are an owner of the firm, you don't get an extra payment for originating the client and bringing them to the firm because, you get that through your partnership. It's traditional. That's what you're doing, right? Origination agreement is intended to reward people like me, like Beth, bringing clients to the firm instead of taking them for themselves, running their own, because most of us have other practices, right? I don't know. Beth said she has a dental practice. So instead of bringing it and doing the work yourself or giving it to another law firm, you're paid this origination fee when you bring that work to the firm. If you're an owner or a partner, that's your whole, that's what you're doing as an owner or a partner. You don't get paid extra. But you know what it certainly isn't? Profits. Getting paid 27% of your billables for that particular client is not for the profits of the firm. That's a totally different calculation. This speech what Mr. Kelly told you about when asked Ferris why is she on his emoji? No. And she on her way out the door. I think I remember and said we wanted to include her more in financial decisions, which I'm sure that was other times that was the reason. This particular reason was because they needed to figure out what her origination fees were supposed to be. That's what you heard in testimony elicited by Mr. Kelly, what she thought she was shorted, right? When she thought she was shorted for hourly bills and origination fees, she thought she was doing her management fee, right? That's what the meeting with the CFO is supposed to be, to do this calculation and figure out what her origination fee is supposed to be. Nowhere. You can go through the documents 3 times. You will never find the document where she says, I need to have partnership application. I want to know what my capital account says, or what's the P&L for the firm. You're never going to find it. the accounting. This is it. The firm shall provide Texas Nexus Legal Group with documentation regarding how quarterly origination payments are calculated. That's the financial information to which she is entitled. Tiny subsection. Her clients, her buildings. And she doesn't. Thing is, okay, he's a control freak, right? It's his firm. But she doesn't say, no, you're partners. Where are the P&Ls? Where is the tax return? Right? What? It's not even demand. And so then there's just batch-free, document-free talking about, well, I told Ferris again and again, guys, these people communicated on text, WhatsApp, Slack, email, and a brother and sister. They also talked to a whole bunch of other people. They got group threads with Brother Basso. They got group threads with Megan, right? And in all that documentation, you don't see, I need a partnership accounting, Ferris. Even on her way out the door. Show you that document in a minute. Her own exit strategy. Isn't that part of the exit strategy? Pay me out, buy me out. Go to the bank, get a loan for, $50 million to buy me out of my share. No, she says, I'm leaving the firm. I'm taking my clients with me. That's what she says. If she was an owner, you would see it in writing. What you see in writing are her agreements to be compensated as a contract. All right. This is Exhibit 39. That's tiny. I think this is my favorite document in the whole stack. The If I Was Really a Partner document. Her words. Not complicated, like corporate structure stuff. Not his words, right? About what he didn't want. Her words. I don't want to wait to be paid until clients pay. I would do that if I were really a partner. Well, she's not. And that's what Beth said. Beth Revere said, that's what Linda said to her as well. I'm not a partner. That's my title. But I'm an independent contractor just like you. And you see it here because she doesn't want to share it with life, right? Why should she take the risk? And that's really at the heart of being a co-owner is the risk. You share the risk with the possible reward. And she doesn't share any of the risk. The document that Mr. Kelly just showed you about the malpractice where Bear says, what you've done really is expose me and the firm to malpractice. Our insurance policy is only a single claim policy. When he says our insurance policy, he's talking about the royal we in the firm. Not dilemma, because you don't get from her where she's like, I'm on the hook for that. In fact, she's not because she took her clients with her to her new firm and she's done. She's not on the hook for the liability. You won't find anything in any of the documents that show a single dollar. Talks about sweat equity. There is real money involved, even in running your virtual firm, believe it or not. Your people, your hourly contractors expect to be paid even if they complain about what they're paid, right? They are paid even if the client's on 30, 60, 90-day delay. That was testimony from Ferris. Also from Beth and from Amy, right? You're getting paid even if the firm's still waiting. That requires cash. And when the firm's running short of cash, Sally didn't have to reach into her pocket. She wants to be paid. She expects to be paid whether the clients
Thank you for the cheers, Monica. Thank you.
pay or not. She's not an owner. That's
All of you who think that you can share in that because you're both co-owners of Court Vibes, you didn't get it signed. So those are my bets, my cheers. I get 1 penny for each of them, and they're all mine.
Exhibit 39. Midday. Oh, no, that's a different one. When she leaves, this is around the time that she said, I quit. And it's like, CFO meeting, says,
She quit.
You're exiting the firm. She says it herself. This isn't a stable job. I don't want it anymore. All along, what she wanted was more money. And hey, I get it. Right? I also understand that I have siblings and I have a kid. That I can appreciate that she thought that it was not right. That she had taken on
I
this
agree. You should.
responsibility of growing litigation practice and wasn't being cut in properly. But that's the deal that she is. Right? You don't need to write that. How can you not?
Everybody who chats during my live stream should actually, get something for that. You get, emojis that you can post. That's what you get.
Exactly what she's trying to do. And she tells you it's not a stable job. It's a job for her. She doesn't own it. This is the same email with some cool graphics. This, maybe my second favorite document. This is Exhibit 26. This is, you'll see the date stamp or whatever. They're negotiating the exit or whatever. And Ferris, he says it was in a sentimental moment. By the way, if I die, well, what did she say? Ugh, yuck. Like, that's the last thing I want to hear. Why? Why? She doesn't. When you don't hear her say it's already mine, doofus. Doesn't say that. She says, oh, that's the last thing I want to hear. She doesn't want the risk of it. She never did. She just wants to be paid a bigger piece of pie. And she doesn't
Digimon is
protest.
better than Pokemon.
Like when he says, we need to get that document in LLC documents. Again, it's just another of all of the examples in both binders where times where it would have really made sense for her to say, I am an owner just like you. Stop treating me like your employee. She doesn't do it. Never. The first time she says that she's a partner or owns anything is after she leaves.
After she leaves. That is the first time. Jude, you already did. After she leaves is the first time she told anybody in the entire world she was a partner. Jude, thank you so much. Thank you. Oh, she sent it to me instead, Bobby. I got your birthday cake and I ate it. All of it.
After this litigation starts, and she said, turns around and says, I don't have this whole thing with you. I own this whole thing with you. Okay. The important part of this is Will Small in the corner, so I made it. This Mr. Sully.
Show him that icon that Chinny just posted and say, to let him know someday this icon could be yours.
Is a very
Maiko, it's of you. It's your icon, Maiko.
intelligent, shrewd lawyer, and she's been an attorney for 20 years. She has a very
Obviously, because we are here in this spot, neither of them are intelligent nor shrewd. Both an intelligent person or a shrewd person, definitely someone who's both, would have signed a contract because they're lawyers. Whatever.
gay,
Whatever.
and she has run for judge 3 times, including 2 times for district court, big court.
So is she gonna just, she gonna give them sentences with a handshake? You have to do 3 years now, okay? No, she's gonna get it written down. Sorry.
She knows what it means to own something, a business asset. She's very clear. We had a partnership together.
Ooh, 6
But
more
when
days.
she ran for judge twice, in 2022 and 2024, way after 2019, when she says that she became a partner, and way before today, when there was a big fight, she was required to make disclosures to the Texas Ethics Commission because she's running for judge. The only thing she says is, look, it says, describe each corporation, firm, partnership, blah, 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 or other business association. That's the box, guys. That's the box where you say, I have an interest in William Maselli PLC, or I'm in a general
No.
partnership with my
Thank you,
partner,
B. But
Harris
no.
Maselli, an attorney. Why are people required to fill in these things? Thinking on it. Conflicts, right? That's exactly what you want to disclose. I own a firm with my brother, who also practices in this jurisdiction, who has business interests all over the world. You got to know if your district court judge owns those sorts of assets, and it's right there. What was Ms. Maselli's testimony? I didn't think I had to disclose that. Well, I think she did enough.
She's making some really good points, though. Really, really, really good points.
She had to disclose that there. And here's the good news for her. She wasn't lying on that floor. Right? She told the truth that the diamond's not suspicion. Thank God. And she
I can give you guys something that it's not money. I can, though. I really, really can. And I have. Here. I could give you judges that nobody else sees. I can do that. Like this one. So maybe this isn't the best example. But, look. I will continue to search for judges that no one else shows. That's what I'll do.
signed this document under penalty of perjury. This is the truth. That's what she owns. Texas Nexus Legal Group. Not what is LLC, not the properties that you've heard about that are not in charge, not all that other stuff. Not anything with him. Her fault. And that's it. Let's take her at her word. When she says under oath, this is what I own. Let's believe her. Same principle. When she's not in a jury, she's talking about getting her deal. When she's mad, she says, I never worked for a less professional firm. Should have quit. I'm taking my clients with. If she were truly an owner and partner of the firm and she decided, I want to still be an owner, participate in that, but I don't want to work for it, right? She would still have duties. Right? She has some duties. She never had that. I'm taking my clients out the doors. What? You owe. It's supposed to be involved, right? She's not close to acts. And again, it's the interest of what she does. She never thinks about it.
That right there. She did take her clients with her. So, if you're an employee of a law firm, you are absolutely not allowed to take your clients with you when you leave that law firm. If you're an owner, you are. Law Talk with Mike. Good. Good, I'm glad he showed him. Judge Fish is amazing. He deserves to be seen. Maybe I should send Mike some clips.
And then?
Zach will. Never mind, Zach got it.
This is your exhibit 36. It's the last page. You heard this testimony. Front page is an email. Then there's a termination agreement. That's not an agreement. Termination agreement. You are terminated. Your ICA is canceled and terminated. Right? And then the last page is Lemma's exit strategy. There was no dispute. This one, I mean, she and I felt about it. He created this exit strategy on July 19, 2024, where she said, I'm going to fill up this is what we're going to do. Fill up my brand. I'm going to apply that I originated, sign into my firm. I will solicit fair safe clients or L&M's contractors. I'm open to accepting work from L&M as an independent contractor. Guys, if it's me, my firm, I think I own it. I think I'm playing a profit share. We put that on the list, right? Like, we will submit the books of the law firm to an independent CPA who will calculate your buyout for my share. This is where you put that on your way out the door. Otherwise, I mean, you're going to be treated like the contractor that you are.
I'm scared to open Discord while I have a live stream running because everything will shut down. But if you tell me you want me to, I will. But if you tell me it can wait until after my live stream, I would prefer that. So, do I need to open my Discord right now?
We don't believe my guy. Just listen to her. What she doesn't say.
But Michael, I swear, he's this big, I swear.
You've got all the Chase documents
I
here
caught a
in the
judge
in your writers, and Mr. Kelly talked about when she was initially added as a signer. Right. I don't know about any of you. Sometimes you're a signer on somebody's bank account doesn't belong, right? You get to, I don't know, make rules with the bank. The bank says, what do you want to do? What permissions does this person have? So yeah, and this is important to talk about.
Thank you.
She was given responsibility. She was given management privileges and access. She did interview people. She did make hiring decisions. She did. Because Ferris couldn't do it all. He can't do it all. But he's always the last word. He's always the veto. And we heard that from Matt. Right? Is that at the end of the day, if you don't like the hours, and Lemma says you should pay those hours, whatever, there's a disagreement. He's the veto. She has management responsibility that is always delegated. She doesn't have true control. The same thing's true with the bank. She's added as a signer. This is the last signature card. You've got all of them in your binder. So at first in 2020, I think that's what Mr. Kelly showed you. She's added as a signer and talked about it in the testimony. Mr. Kelly said it was COVID. In fact, the weekend, I think it was like March 13th, 2020 is the date on that first signature card. I remember that day. That's like COVID weekend. That's the day that everything was totally shut down, like the last weekend. And so we're thinking, I'm going to be out of the country. He has her as a signer. What's that say? This is what she changes after she leaves, guys. She makes herself a member. Because that has increased rights and authority. That's not how she's originally put on the account. That date, August 9th, 2024. This may be my third favorite document. Number one, it's inconsistent with her story now, right? She knows she's not a member of the PLLC, right, of the actual structure, because she's also seen all those forward documents. She knows that's not true. So now she says, well, I have a partnership that includes this asset, right? Forget about the forward structure. But the really shocking thing is that she also knows that she's got no business going down to the bank and changing the signature cards. She's already quit. She's out the door. Why is she going to the bank on August 9th and saying, Ferris, not present, and changing the signature?
I double dog dare you to use those today. In every conversation you can. Squeeze one in. Even if it means no, even if it makes zero sense with the context of what you're saying. Just squeeze it in.
I mean, we know why, right? Because she waits a little while, then a few months later, she comes back and she takes out the $75,000 that you've heard is the real reason why we're here.
Check to that last comment, Judge.
It's sustained.
I think that this won't draw an objection. And July 16th, I quit. Here's my exit strategy. She said, I'm taking my clients with me. And then a couple weeks after that, she goes down to the bank and she unilaterally changes the signature cards. Okay. That's not controversial, but let's let you look at it. They terminate. Fair says, please, counter accept. And then she said, I'm a member. And eventually withdraws $75,000. So, in addition to the documents that you saw, you also heard from witnesses. I talked about some of the witnesses basically. Mr. Kelly, who is a very, I think we'll agree, skilled trial attorney. Right? He had my client on the stand for like 2.5 hours in very exciting and back and forth that had almost nothing to do with this case. Right? We talked about he talked about all kinds of things. What he said down in the cafeteria, what he said about his Apple job, some stuff about whatever. What I didn't really hear anything about is questions about Lemon's right to share a profit, Lemon's exposure to liabilities, Lemon's control, because the facts aren't great for this. So, the plan is we're going to make Mr. Maselli seem like kind of a jerk, and he called her his partner. That's it. And all the time that you had Mr. Maselli up on this, he asked Mr. Maselli on the stand, we're not spending a lot of time looking at documents about the functioning of this firm and finances of the firm. It's like side quests to attack his credibility. But you don't even need Mr. Maselli to be credible because Ms. Maselli says it all herself. She's not an owner. She's an employer. She's a contractor. She receives wages and compensation. We also heard from a couple other people. Beth Revere doesn't work at the firm anymore. It's not like she's on payroll, right? Mr. Kelly knew her. They worked at the city attorney. They knew her from the city attorney's office years ago. She's been a practicing lawyer in this jurisdiction for 30-something years. And she seems like a kind of lady that doesn't put up with a lot of trouble, right? And she says that Lemon said to her when she complained about, hey, I can't help you.
Yeah, but, JK, hear me out. You would start a business with me, right? Because I have a lot of business ideas. I just need people. So, like, you would start one with me, right? Right?
Partner's just a title. I'm a contractor just like you. Talk to that guy. And ultimately, Beth quits because she and Ferris can't get on the same page about her hourly rate. Right? You are the sole judge of credibility. That is pretty credible.
Would it help if I said, I just don't like you? Then would it help?
As far as I'm concerned. Then you heard from Megan. I'm sure you're expecting some sort of Jezebel, right? Because you've been told she and Ferris are sleeping together, they're having an affair, he pays for her manicures and all this kind of stuff. And then what do? You get some girl from Wisconsin, right? Who is one of the hardest working people I think you might come across, who tells you what's going on. That she works all the hours because as she has gained experience and educated herself and made herself useful to the firm, right? She has been given more and more access, responsibility, opportunities to learn things. To meet people who will help her develop into an ever-growing professional. She said that she'd come here to coach gymnastics. I know that's true because she was my own little girl's gymnastics coach. You're the sole judge of credibility. She's a person of integrity. And this is their story, right? Like he's living with her. And Mr. Hallivan gets up and says, some kind of stuff about body language. All hands me come. What Megan was also able to tell you is that she's the custodian of record, right? She knows what the corporate documents are, and she works very closely with Mr. Maselli, and she's familiar with their workings of the firm. And you know what? She also used to be super close with Ms. Maselli. She gave her clothes, right? As she said. And she's helping with her little girl or whatever. They were friends. And it is true that Ms. Maselli doesn't like the relationship between Ferris and Megan, but it's not like romantic, not like. It's like this. And she doesn't like the access and closeness and trust that Ferris puts into Megan because he doesn't trust his sister. He said it himself. When you get to the end of your form and you ask yourself, how am I going to answer this question? They did not create a partnership known as Boyd Maselli PLLC because it already existed, because they never operated as owners and didn't intentionally. Ms. Maselli doesn't share in risk. She doesn't get a share of the reward. The I'll pause there for a second. The idea that your profits is like that hour, like half of the billables that you get for your hourly
Lots of fun.
means that that reviewer would also be an owner. I would be an owner. I really want, like, that's wages and compensation. This is how you do. Okay. None of the 5 factors.
Ms. Farrell, I'm sorry to interrupt, but you have 10 minutes.
That's perfect.
I'm glad.
None of the 5 factors have been met. The strength of their case, and he called her a partner, and he did. But you know what else he heard? What you heard that wasn't controverted is like, especially in the early days, he called lots of people as partners. It's in Syria, right? I'm forgetting the other examples because he was trying to portray like it was just everything, as Ms. Rousseau said, right? He's trying to portray that the firm is, great, has great weight before you get there, right? You're the partner for the bourse. And he's not thinking about a partnership conveying equity because they have written up the evidence. As Ms. Rousseau said, that she told that, it's a title only. And that's it. That's all they got. Is that he called her a partner again and again. And like that's not the vibe. That's not you heard uncontroverted testimony that title is used for non-equity partners at other firms, including the firm that Mr. Mussolini started at, the LA Markets. And they've got equity partners and non-equity partners, and for public gravitas, it's called partners. For Mr. Mussolini's testimony that when his sister joined in 2019, she had not been yet made a partner in any firm. And he wanted her to have the respect of the team and the gravitas of the outside world that title conveys, where the title partner in a law firm, if you're watching Suits or LA Law or whatever, means senior person, boss person at a law firm, right? And if it was supposed to convey,
Eileen, that was a caption mishap. The lawyer didn't actually say that. Lawyers, see, in this courtroom, luckily, we get mostly lawyers. This is mostly civil in this courtroom. Some pro se, we do get some pro se, but all these lawyers know how to act in a courtroom. So when we see a case from this courtroom, it's mostly about the story and hardly ever about how people are acting, except the last clip I played from this courtroom. That was just about how they were acting.
ownership, there would be an agreement for that. You would have a written partnership. They're both lawyers, right? If that's the agreement they wanted to have, you would have it and it wouldn't be happening. Why? I thought a lot about this, folks. There's kind of 2 philosophies, I think, of dealing with conflict, right? She's definitely mad at her brother when she goes away. She thinks he owes her money. She doesn't like how they did that whole splitting up clients thing. She's angry. And he, kind of maybe because they're brother and sister, then like even they think he's digging his heels in. You're not anything. And so she makes a decision. He owes me this money. You got documents to talk about it. And so she took that bank. And when he's mad about it, she doubles down, right? She says, I'm an owner. I'm an owner. The 2 schools of, I think, that been thinking about conflict resolution is deny, attack, make counter accusations. That's what they're doing. That's what this is. Right? Instead of, and you're wrong, right? Now you made a mistake, seek reconciliation and say, all right, maybe I should have done it like that, but like you owe me money. Instead, she says, I own this. And that's why you don't see it until now. That's why it's not in documents. Because it's a make counter accusations response to his actions. I'm sorry that you are having to be the arbiter of a dispute between 2 lawyers. and a brother and sister. But sometimes you just need neutral people who can take a look at the facts and say, this is what's right. You don't have to like either one of them, right? You don't have to rely on my client's verdicts to look at.
I don't control that. It's just a feed that it grabs. So there's nothing for me to click or move or touch. It's a link. I give the program a link to live chat and it grabs the feed. So I can't change it'll go away as soon as the poll is over.
Access to the interview and document that you have. Hope that I showed you if you don't want you. Go back to the jury when you feel confident in saying, maybe I don't like how this went down. I have my opinions, but she doesn't own it. They don't have a true partnership. I appreciate your time and attention.
Yes, it is.
Turn over to I also want to acknowledge
No, it's not.
that how this affects my last 1 minute. This is also families, and it affects other people's life.
Objection, Your Honor. That is an improper argument to talk about somebody other than these parties.
Okay, please join me up here at the bench. Right, the objection is sustained. I miscalculated my time. Ms. Farrell actually has 3 more minutes.
I don't think she takes 3 minutes, but I
Your
could be
role in our
wrong.
volumes dispute is important for forever. And we very much good time to make a final determination. And very big part. There's one more little fact. Everybody knows me, man. I just want to say things. That we talk about how Mr. Maselli owns her law firm. As you just said, think about home for Kelly's talking documents that you've seen in that week and say no and ask. Thanks very much for your time, Isabel.
Thank you, Ms. Farrell. All right, Mr. Kelly, it's rebuttal. You have 13 minutes left.
Okay, we had 12 votes, and 75% of you think that she lost and she does not get any of the money.
Myself, a great speaker, I've always had trouble with it, but I do consider myself a really good cop. And that's what I've done. We talked about that a little bit about even, I go after the facts. I don't really care about personality. I'm going to tell you a couple of things, and I want you to see the judge's question, and why it's worded this way.
So let me see. I'm not going to have a lot of time to cover everything, but I am going to. What's the fight? The jury fight. It says, did they create Lloyd and Maselli PLLC? Look, first, even if this operating agreement was signed, and I can show you why this is, but the proof is in the evidence. She got up here and bolstered Megan now after what we've heard. What do we hear about Megan? First, it was Ferris testified she was an employee, and then he tried to deny it here in this court, even though he just testified under oath briefing, but that's wrong. And then she gets here, I'm not an employee. You see, this question is worded this way because this is the question the judge wants. Doesn't say LLC. It says PLLC because we know the date of that. We know it's when Lemma is there, and Lemma is there in the 2020 region. And that is document 5. What does document 5 say? This is in evidence, and it says, the name of the filing entity being formed is Lloyd and Maselli PLLC. We heard Ferris admit that the LLC was an improper form. No dispute about that. It was improper to practice law that way. This now limits it, as it should be, to the purpose for which the company is formed is the practice of law and services ancillary to that professional service. Because you heard a PLLC can only have lawyers in it because we are governed by a special rule that we can't cheat the public on fees, so you can't share fees with a non-lawyer. It has to be a lawyer in that firm and nothing else. And the whole structure that Mr. Ferris put together would have been illegal for lawyers because it had a corporation and an LLC, and that's not the way you can do this. It may be great for taxes, but that's not. So, but let's talk about Megan, because she boasted her, after this testimony, you lived in all that she ever asked her was about being gymnastic. She never asked her the elephant in the room. And I remind you what that was. Ferris testified he had taken, and he admitted it under oath, he had taken Lemma's birthright. We were talking about that piece of land from the father. And Megan, on stand.
Search, please.
So we get to the part of the,
Let me be, for the record, the objection is sustained in part, overruled in part.
what we were talking about was she got on the stand under direct, and she's had Miss Marine Farrell. Asked her, huh?
Farrell.
I said Farrell.
Oh, I missed it.
John. Miss Farrell asked her about going to the dad's funeral. And it triggered in my mind, wait a minute. So I asked her, when did you meet the dad? She never met the dad, ever. She testified that repeatedly, and it was a fact that was bugging me. I said, you've never met the dad? No, I've never met the dad. And then I presented her. She's never been in this process. Did Ferris take you over there one day to meet the dad? And no doubt he died. That was in evidence. No doubt that the only time she ever saw her dad, and actually, the only time you ever saw him was in the funeral. And she said, no, I didn't see him then because he was dead. The only time she ever been in the presence of the dad had been at the funeral after he's dead. And yet, a month later, she's notarizing his signature on a deed. That is credibility. And that's why we covered that. Because once somebody is proven to be a liar and have committed a forgery or anything like that, you're the judge. Instruction to.
Hold on, you have an objection?
God.
You can come up.
The point being, if they had Megan up here to bolster his testimony, anything that I asked her, did Ferris get you to do this document? And she wouldn't even answer that. Anything Ferris wants her to do, she's going to do, including go past the limits of the law. So her testimony is not credible. I don't care if she's a gymnast. We're all bound by the same rules. So if somebody back there says, well, Megan said this, you're the sole judges of the credibility of this. What did she say about partnership? She wasn't even there. What did she say about this relationship when they were always fighting? No. What we heard was Lemma presenting whether she's sleeping with him or not, or whether him sending the inappropriate pictures that clearly was admitted to, and anything like that. All of that is irrelevant to the partnership except for one thing. They keep talking about her having no role in management, and she's going to the man who's the managing partner and telling him, this is the rumors, this is stuff you can't do. They even denied it ever came up about paying her manicure and pedicure. And then finally, Megan testified, well, he did offer to do it. He did talk about it. But then they all, they want to talk about the books and records. So it is very clear that Megan will do whatever he wants, including going way past any limits. Her testimony up here. So we are looking at the section on credibility and witness. I believe Ms. Revere was telling the truth. It doesn't mean people remember everything. She had several times not gotten paid because Ferris is a cheat. He cheats everybody. Everybody that's coming here saying, okay, I had my correct count. We also know something else from Ms. Revere. After she was testifying, I didn't realize, I know this lady. I can see her face. It took a while. But she did exactly what most women do. And they try to walk away from the fight. Even in the void, you remember one of the jurors said, I had this dispute with my family and I had this lady go. Women trying to exit. And that's what you see them trying to do, is doing exactly the non-conflict. And men do it too. Some men do. But men generally are a little more aggressive when you're going to cheat us, right? We're ready to blow up. We may get cheated in your face. Women try to look for compromise. It's just no differences. Not that I say it's wrong. It's just they've not had a history of being able to fight for their rights. A lot of folks are like that.
Mr. Kelly, just so that you know, 3 minutes.
I know, and I can't cover everything, but I want you to see this document. You get back in there and say, hey, look at this independent contractor. Even if it was for the LLC and that was before. And clearly he had access to her passwords and all that, and this could have been him. But it doesn't matter. It doesn't disclaim, since he's the great lawyer and the great doctor, nothing in there says this disclaims a partnership. I don't claim a partnership. He says this document doesn't create one, and we've never said it created one. This is how she got paid, and this is the other agreement. Why does this one say the Lloyd and Muselli is with the signature, which is, this is the original engagement 25. This is the one, the Texas Nexus. Why is she getting Texas Nexus? She explained it. This is how I get paid for my taxes so I can pay my Social Security. That's exhibit 25. So these don't disclaim anything. As far as saying, I don't want to think about my brother dying, it's because she did love her brother. She didn't want to talk about it. And they want to spin that around like, I don't want to take over the firm. He said, I want you to have the whole firm. I want you to inherit this whole firm. That's great. Because he would have had an interest in the partnership even if he died. Somebody else could have got that. He said, no, I want you to handle it because you've helped me build it. That's when they were getting along. She repeatedly tried to exit, and always the exit was, let me just get out of here and I'll take my clients. What firm let you take their client? It really just is. What firm is going to let you take their client? She was a partner. That's why she could go quit, whatever. There was no formal document saying you're gone and these are your clients. I established it. So I've got to hurt. If somebody gets back there and says, oh, but she told it. She disclosed on a document that was public, the Texas Nexus, which had her brother as a member. That's how she got paid. She explained it. She also said later she amended it, and it was disclosed the partnership. More importantly, that's not this. It's not here. She said nothing problem with that. That didn't say I'm not a partner. She just listed what she thought, and then publicly we have Exhibit 1. Asked for it to be played back there, or we have the hard copy. Every one of these say, I am partners. Exhibit 5. This is my litigation partner. All the company documents say litigation partner when it became Lloyd and Muselli. So we know she was.
Oh, Monica, you should have waited one more minute for those cheers. All right, guys. We're about to hear the verdict. If you're ready for this.
A partner back when it was Jason and Lloyd. That's back in the LLC when just went too fast. And I thought, So I'm going to close that. The undisputed evidence is that they were partners and they meet every one of those. When you consider the evidence and how she got paid, not one is dispositive, but they all point to a partnership. They all point to her doing exactly what the video says is building the litigation side, which he had 0 employees, 0 lawyers working for him when she came on board in 2019. And every document, including the little personal thing, said, Greg, thanks you for building this firm, Lloyd and Muselli. I want to thank Lima and Ferris. And he thinks he can just sit back and I can cheat everybody. Well, sometimes people fight back even if they've been pushed too many times. You've got to be careful because Beth didn't want to fight him. Shay didn't want to fight him. And these are lawyers. Why didn't Beth want to fight him? She'd been cheated multiple times and she was clear. I don't doubt she was cheated again. He just walks away. That is not the same thing as saying you don't have rights that can be enforced. And that's why we're here. Miss Lima Muselli had a right as a partner. She was a partner beginning in 2020 for sure. And nothing ever said, this guy could have written the best document ever. You are not a partner. You are.
So unfortunately, it cut there. It was the feed cut there, and then the judge stopped it, and then the jury comes back in. So that was the end of his closing statement anyway. So the jury is about to come back in with their verdict. Here we go.
Go ahead and be seated, please. You said you are a jury foreperson, is that correct?
Yes,
Tell us your name.
Jessica Davis.
All right, Ms. Davis, my understanding is the jury has indeed reached a verdict.
Yes.
We've handed the verdict to the bailiff, please? Thank you so much. All right, so question 1. Did Karis Maselli and Lemma Maselli, formerly known as Lemma Barazzi, create a partnership known as Lloyd and Maselli PLLC? The answer is yes. This is a verdict. Is signed by 11 of the 12 jurors. Any motion?
Motion to accept the jury verdict.
Yes, I will accept the jury verdict. Are there any other motions?
Probably file a JNOB, but we don't have to now.
Okay. Any others? All right. I will ask you all to retreat back to the jury room, and I will be back in there shortly to release you from jury service. All right, so the jury.
So here's what this means. It's going to take a year or more for it to get there, but she won. She is she is a partner. So now they have to go ahead and they have to figure out what money he has to pay her. And he's going to have to pay her all that money. And to do that, he's going to have to provide all of his books. Remember, he didn't want her to see the books. So he never showed her the books. So they're going to have a hearing. Appeal is probably going to happen. Then they're going to have hearings, evidentiary hearings on financials and things like that. And then he's going to have to pay her money. Unless they appeal it, nothing will overturn that jury. That jury said that she owns half of that law firm. 1/2. Is that not crazy? Brother and sister. Oh my goodness. I thought he was going to win for sure. I was for sure certain that she was not a partner. Although she did take that $75,000 after the fact. Months after she was fired or quit. Months. But I don't know. I thought he won, and I thought it'd been too bad, so sad for her. At least she got all of her clients. But no, she took all of her clients, and she gets to be paid. My goodness. All right, guys. I'm going to start tomorrow, I think, with Judge Nathan. I think so. And we'll see where it goes from there. What is today? Today's Monday. Get to work. Go to work. I'll see. I'm not either, V. I'm not either. She should not have won. But she did. That's the way it goes. That's just the way it goes. All right, guys. Yeah, well, families fight and get back together and fight and get back together and fight and get back together all the time. So, you guessed it. Not me. All right, guys. I'll see you in a bit. Thanks for coming out. I appreciate it. I'll see you soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,